Welcome back to the Cordell and Cordell Town Hall, where we're going to talk about child support and spousal support and how COVID-19 has affected all issues of family law before, during, and after divorce. I'm Scott Trout, CEO and managing partner of Cordell and Cordell, and as you know, we're the world's largest domestic relations law firm serving men of its kind, and now in our 30th year. You can check us out more on the web at cordellcordell.com. Or in fact, you can contact us if you want a virtual or telephonic or in-person consultation where appropriate at 866-DADS-LAW. So today, as we continue to do each Thursday, we take your questions live. We also take your questions, I as the moderator will read them. But if you want to ask your question live of our panel of Cordell and Cordell attorneys, you can do that right now by submitting that question via the Q&A section on your screen, and let them know you'd like to ask that live. If you'd rather just submit a question that I can read and have our panel answer, you can submit that via our chat box. And when you do so, just go ahead and list your first name and your state so that we know where you are, and if appropriate and if possible, we can kind of refer to some of the laws and the local rules in your state where appropriate. Also keep in mind before I introduce our panel that we don't want this to be a misunderstanding of an attorney-client relationship. We know that each of your facts, each of your cases are different, and they may dictate something different in terms of how we proceed, how we advise, and really some of the laws that we would tell you. So again, we talk about this each week. We encourage you to take this information, go seek an attorney, and have that consultation. Certainly, as I suggested earlier, we also are available. Also tune in each week or each day to my daily podcast, where we spend about 15 minutes talking about individual topics related to COVID-19 and its effect on family law. Now you can submit questions each week, one day each week. I'll address those questions at coronavirus.divorce@cordelllaw.com. Coronavirus.divorce@cordelllaw.com. Keep in mind that I'm only licensed in Missouri, Illinois, and Georgia, and our guests, our panel, are licensed in the state in which they told you. Again, this is not an attorney advice or attorney-client relationship, so keep that in mind. So let's go as we start each virtual town hall. We talk about what's in the news, and we have a repeat offender. That would be Kristen Cavallari, who last week we talked a lot about where she and Jay Cutler were going back and forth among themselves during this pandemic. One using the house, trying to get a house proceeds for exchange for leverage on custody. And now, as many of you may have seen, she made the news by using more social media, as most celebrities do. She decided to post herself as a fake online Instagram account as Jay Cutler, wishing herself a happy Mother's Day. You know, at first glance, I thought, well, she's just making Jay look nice and kind of a nice gesture, but I think there's more to it as I read through it, and that is trying to really overcompensate, I think, for what her perception is as a mother, because again, custody seems to be an issue here. So let's turn to Oliver. Oliver, really, the question becomes the use of social media. I've talked a lot about it. I was on Dr. Phil years ago when this first came about, the onset and the use of social media. But I assume, if you're Kristen's lawyer, this is something that you're going to counsel her on to just stay off of, right?
Yeah, absolutely. I mean, I think Ms. Cavallari needs to be reminded that when you're going through a divorce, you're subject to a higher level of scrutiny than you would otherwise be. So, she wants to assume that everything she's putting out there on social media, and a lot of times even things that she's doing in her private communications, whether it's email or text, are going to be reviewed by a judge. So, she's going to want to stop these things. And if I was advising a client here, I would be advising him of the potential to obtain a court order, which would restrict her ability to keep doing these kind of things. And I don't think this is going to be taken very kindly by the judge, especially when you consider her role as a public figure and the ability of her message to reach a wide audience. So I would think she would want to stop doing this sooner than later.
Yeah. Jessica, I'm going to go to you. I mean, I think I've always told my clients or prospective clients that I don't ever really foresee an opportunity to use the social media platform that would ever benefit me in any way. I don't care what you're posting. I don't see it as a positive. And I want to know if you would agree. And then obviously I think that Oliver alluded to it, and that is judge is not going to look at this kindly, and in fact it'd be used against you, don't you think?
Right. I always tell my clients just to stay off social media. As we all know, what we say and the intentions of what we say are often different. How people perceive of what we say is very different. So your spouse might think that you might think you're saying something nice, and your spouse might lose it because they're interpreting another way and share it with their attorney and everyone. Secondly, the judge does not want to see social media. I don't know any judge who likes when we share Facebook or Instagram photos saying this is what they did. And, you know, Kristen needs to be sure that she's not setting herself up for failure. She's here to make sure that her case is going to be the best case that it can be. And if she's on social media lying and making posts that aren't true, that's going to be brought into court and not put her in a good light. So she really needs to stay off the social media.
Yeah, I just don't see this. I mean, I see it comes into question in everything, in credibility. That's huge, especially when it comes to representing guys. And now it's going to come into question about her decision making. I don't care if she's a celebrity or not, and they live on social media and they thrive on social media and they make money off of social media. It's just a disaster. And the more you look at it, I don't see how she comes up with any excuse. I don't even care if it was a joke. I think as her attorney, you're right. So let's talk about, you know, today's news, and every Thursday we get the updated employment or unemployment numbers, and we added nearly another 3 million to the unemployment roll. And albeit that the numbers continue to shrink of the increase, we still have now almost 36 million unemployed. And there was an article in Kiplinger that talked a lot about the struggle to pay child support and alimony. We know that's real. We know typically when guys come to see us, I'm going to turn to you, Carly, guys really live paycheck to paycheck. And the question that many of them have is, you know, we've been trying to talk about for the last 7 weeks or 8 weeks is really some tips. And I think Kiplinger was right to kind of go through this article. And I think one of the things that I have a question for you is really discovery. We've talked a little bit, just a little bit about discovery in our past town halls, but why it's important to think about, one, your income and your ex's income too, because if she likewise is receiving a decrease, it may affect your ability to modify. And to maybe talk about how discovery could be used in that regard.
Absolutely, Scott. Great question. So whenever you file a motion to modify, whether you're modifying support alimony or if you're modifying child support, you're going to want information about not only your own finances, but what your ex is going through during this COVID-19 crisis as well. So issuing, even if it's just a few discovery requests, and discovery is just the legal process for getting information from the other side. So in Oklahoma, when you do a motion to modify, you can ask 30 questions under oath that she's going to respond to. So you can ask her questions about, is she earning extra income during this time? Was she on furlough? Did she get some sort of severance package? And getting all of that information so that you can use it in negotiations. And then if you end up going in front of the court, you can use that to present your evidence for your motion to modify.
Yeah, it's so critical, especially when, you know, in child support modifications, which seem to be a little bit more straightforward. Michael, I want to turn to you. When you talk about alimony, maintenance, or what we've often commonly referred to as spousal support, that tends to be maybe a little bit more difficult analysis, right? Because you have to pull out your judgment and determine whether it's modifiable or not. Maybe you can explain to guys really what they're looking for here and why that matters.
Sure, Scott. Once again, great question. I think, you know, when it comes to spousal support, as we, you know, as you probably discussed in prior panels, child support as a base is always going to be modifiable based on the change in circumstances, a general proposition. Alimony operates a little bit differently. You know, depending on the language in your your property settlement agreement, it may be modifiable, it may not be modifiable. So your first step is going to be to take a look at that property settlement agreement or that order and determine whether the alimony is modifiable or is non-modifiable. But what I would say is, even if the language in your property settlement or agreement indicates that it's non-modifiable, it's still a good idea to consult with an attorney. There is some tension between contract law versus once you have a final judgment entered in a divorce, typically your property settlement agreement will be incorporated and become a part of that order. And that order is you know, tends to apply the law. So the statute would apply. So I can tell you in New Jersey, for instance, under the statute, alimony obligations are modifiable based on a showing of a change in circumstances. So, you know, judges operate very differently from jurisdiction to jurisdiction and even from county to county. And so some judges may look at that and may say, you know, well, you have a contract that you entered into, we're going to view it that way. But there are judges and there are courts who may look at the argument that this is incorporated as a court order right now. Whatever happened may have been unforeseeable. We're living right now through COVID-19. Arguably, that was an unforeseeable event that you could not have predicted at the time you entered into your agreement. So even if the language says it's non-modifiable, I would still consult with an attorney.
Yeah. I mean, I guess the point here is really, and we've been stressing, for the last, number of weeks, 2+ months is, and obviously this is one of the 5 mistakes that guys make is inactivity, and really go get a consultation with an attorney. At least, get yourself the information you need to make informed decisions. And that really brings us to the next item that was out of the New York Times, which talked about how COVID-19 has really slowed the process down. And I don't think anyone is surprised by that in any way, and that we know that the courts are perhaps closed. And again, we use that in air quotes every time, because it depends. And we'll talk about that with our panel about what's going on the ground here in a little bit. But when we think about this New York Times article, James, I want to ask you, the first thing guys should realize, number one, right, is that there are potential that you can file right now. You don't have to wait it out, and you shouldn't wait it out, right?
That's correct, Scott. What you want to do right off the bat, if you find yourself in this situation, is to immediately file an action. If you're thinking about divorce, the reason for that is it cuts off the marital estate. It compacts, allowing more time to pass prior to filing for court for this marital estate to accumulate more or less. You always want to start that process by talking with an attorney. Some folks in the New York Times article suggested going to a mediation and trying to work this out between your spouse. That's something I would highly recommend not doing without an attorney. In many jurisdictions, you could find yourself agreeing to a deal in a mediation with your spouse that may not actually be fair. And if you sign that with your spouse and lock yourself into a bad deal, you may be having to fight your way out of that going forward.
Yeah, absolutely. And I'll call it the Kristen Cavallari rule. And that is, don't use this pandemic as leverage. Or even we talked about Gwen Stefani last week, who moved herself post-divorced all the way to Oklahoma, and her ex-husband wasn't getting divorced. You don't want to use this pandemic as leverage, right?
Never, never. You will be punished if you disobey a court order. These judges are looking to give some folks compassion if they, for instance, lose a job and are unable to pay child support. But you want to be able to bring that issue to the forefront to show the judge, and by filing a motion potentially, that I am not able to pay this, but I'm bringing it to your attention at this very moment, so that at least that stops the bleeding, if you will, and shows the court that you are not trying to intentionally do wrong by not paying your child support or another issue. And therefore, they'll be a little bit more lenient and understanding, in my opinion, under the circumstances and given everyone's unemployment and lack of income due to the pandemic. So it's very important to make sure to notify the court if you're going through any of these issues and job loss or income loss, and filing a motion as soon as possible. And I believe they'll have a little bit more compassion for those individuals.
Mm-hmm. Jared, I want to ask you, as we look at this article, it talked about how the divorce process has really slowed down, and we get it. In terms of filing, it may be stacked up because we don't have the in-person hearings on a regular and routine basis. But when it comes to, and when we tag on to the modification of support, isn't this really the opportunity where guys should be looking county by county to determine how they can file right now to trigger that retroactive support that we've talked about for a number of weeks now?
They really should be looking county to county initially with the filings, be it with support or divorce. There was a big slowdown, but that has started to speed up. Depending on what county you're in, some counties you can go directly to the clerk and file it, and it's done right that day. Other counties, you have to leave it in a drop box. But I have to say, the clerks here in Mississippi have really done a good job of getting those drop boxes done quickly, because I don't think I've had a single time that I haven't dropped it off and it been on file online that day. So yes, it is time to go ahead and start filing so that you can start that modification process.
And we know with the 36 million unemployed, and we know what's going on around the country, we know that modifications are going to probably be one of the most filed actions across the country, if not the world. And I imagine that's more incentive for you to just get on file, get in line, and so that you can be kind of first out of the gate when the time comes, right?
Yes. Even if you're having to get your action continued, you want to be the first on the continuance list, because I believe the court administrators, when they're setting up the new hearings, when the courts do open, they're calling the people first that were on the docket first. So you definitely want to be first in line.
Absolutely. So thanks. We'll get into our specific topics on child support and spousal support now with our panel, moving on from our news of the week. And remember, if you want to ask your questions live, you can do that here in the second half of our virtual town hall by submitting those at the Q&A section. If you want just me to read your questions, you can submit that in the chat box. But go ahead and do that, but we'll get right back to it after this quick commercial break.
Even in the toughest of times, there are usually opportunities for relief. Many husbands and dads listening now are struggling to stay current on alimony and child support orders. You should know that this crisis may allow you to modify your support obligations, but time is of the essence. If you're a guy needing help right now, not someday when things are back to normal, call us at Cordell Cordell. This is what we do.
Welcome back. So now let's get right into really the topics of this week's virtual town hall. We really want to talk all about payments, and that's child support and alimony, you know, what we've referred to as spousal support and maintenance. And I want to turn to Oliver. Oliver, first, as we do each week, can you give everyone an update of what's going on in the court system in Ohio? And so guys know, you know, are they closed? Can we file? Are there actions? Can we be heard? What's going on in Ohio?
Sure. So Ohio, they're really restricting access to the courts as far as physically being in courts. They're restricting the ability to actually conduct a hearing to emergency hearings like domestic violence, civil protection orders, and things of that nature. But, you know, the clerks still are open. You still can file pleadings with the court. And, you know, I think that's so important, kind of going back to what you guys were talking about before we took the commercial break. When it comes to a request to modify child support, when you file, you're invoking the jurisdiction of the court to set that date for retroactive application of any modification realized in the future. So it really is so important to file when you need to file, and rest assured that sometime in the future your claim will be heard. But again, you got to file when you got to file.
Yeah. You know, when guys are thinking about child support and modifications, I can tell you that even before COVID-19, I would hear the, you know, well, I heard you can only modify child support every 2 years. And or I could hear that you only go through an administrative agency, that, you know, through the state, and that's the only way to do it. And there's a lot of misinformation, or I want to say disinformation, that's floating around even before COVID. And now it gets even more complicated with this pandemic, with the court systems being restricted and with access. Maybe you can walk guys through, you know, around the country. And I know Ohio has some particular, you know, ways of doing it, but generally speaking, there are a couple of ways to do it. It's through an administrative agency or through the court system, right? And what's the difference?
Right. So there are two venues where you can address child support. You have the administrative agency and you have the courts. So the administrative agency, it's important to remember that the agency is just an agency. It's not a legal system. It's not, you know, full of lawyers and magistrates and things like that. And if you can, you really want to avoid going through the administrative agency. And I say that because the agency is kind of restricted as far as what they're able to do when they're considering support. You know, they're not able to consider a lot of the deviations, which would serve to potentially lower a support order. They're not able to consider imputed income a lot of times, which would again serve to lower a court order. So just when it comes to efficiency and being able to address all the things that need to be addressed when you're going through support modification, you really want to be in the courts. And then as far as modification goes, the agency, what they'll do is they'll send you correspondence every 3 years, just saying, hey, it's been 3 years. Do you want us to relook at this? And either party can say yes, which would trigger an administrative review. Courts, on the other hand, you can modify support at any time upon the filing of a motion. You have to meet certain jurisdictional requirements as far as a change in circumstance. But again, if you can be through the courts, you want to be through the courts. And that's a little bit the difference between the abilities to modify.
You know, and I think I've told guys that, you know, I think what you get with an administrative agency, and obviously it varies state to state and county by county, but typically, for example, Missouri, you tend to get maybe more inexperienced attorneys who try to run those administrative aspects. They don't have a lot of experience in family law. They're looking for maybe the less complicated, more formulaic calculations and kind of know what you're getting here. I always believe that you have a better opportunity, as you suggest, to looking for deviations and maybe other things that are modifying the total calculation. I think that's really important. And when we look at that, Michael, I want to go to you and talk a little bit about how custody time impacts child support, meaning even either the creation in the first part in a divorce or the modification. But go ahead, before we get into that, update again what's going on in the court system.
Sure. Thank you, Scott. So here in New Jersey, our courts, similar to Oliver in Ohio, our courts are closed to the public right now, but that doesn't mean that things are not happening and things are not moving forward. Just in the last few weeks, the state implemented a statewide e-filing system. I've had the opportunity to file several pleadings myself. It is up and running and operational. Narratively speaking, what I'm finding is I'm getting return dates or hearing dates that would occur when I would have expected them to occur under normal circumstances. And that may not be true county to county. There may be some distinctions, but as a general proposition, even though access to the public is closed right now, the courts are operational and they're moving things forward. They're using technology, whether that be through Zoom, through telephone, to be able to conduct hearings. So what I want to emphasize really to guys is that, as everybody else has indicated, now is really the time to go ahead and put your matter before the court, and there's nothing stopping you or preventing you from doing that.
So, really custody, we talk a lot about some states look at how many overnights you have. That may decrease your child support obligation, or if you have the majority, perhaps it flips it and you're the one that was receiving child support. But does it really matter, in terms of guys thinking how much overnights do they have, or is it just time? Is it daytime? Or really explain to them how that custody and overnights is implied or implicated in child support.
Sure, that's a great question. I mean, backing up as a general proposition, judges typically don't want to conflate child support with custody. So I think in terms of how you're framing the narrative or framing the question, I think that's very important, because they don't want to get the sense that that you're seeking parenting or custodial time based on your desire to impact on child support. But as a general proposition, yes, overnight time absolutely does matter when it comes to child support. I've had many clients who, basically, if you looked at a calendar and you looked at the hours in the day and broke it out, there's an argument to be made that they basically share parenting time with the other parent. But it really comes down to that overnight time. The more overnight time you have based on your own state-specific formula that's built into their guidelines, the less you're likely to wind up paying in child support. And in fact, if, even though you're the higher earner, if you have what we refer to as primary custody, you have the majority of the overnight time. Because the majority of jurisdictions utilize what's referred to as an income sharing model, and you look at the total net income available for support, the other side may wind up owing you child support, even though you may be the higher earner, because you have the majority of the custodial time.
Yeah. I'm going to go to you, Jared, and there was a question, or actually a topic in the New York Times article that we talked about a little bit earlier that we didn't address, and that is mediation. And the recommendation in that article, which I disagree with, and I'm curious about you, not only if you agree or disagree, but how we use it, is mediation, whether it's in divorce or modifications or whatever it may be. Obviously, I've talked about mediation as a useful tool in my daily podcast, but do you agree that in the New York Times article, it suggested that the clients should just go without their lawyers? Do you agree with that?
I definitely do not agree with that. Any type of, be it a settlement conference or a mediation, there's just so much that can go on with a divorce that if you're not dealing with this area of the law, that a layman can overlook. And I definitely recommend having an attorney. Having said that, I do find that right now during the slowdown process that it is easier to settle cases because clients don't know how long it may take to get the divorce, and also other attorneys don't know how long it may take to get the divorce. And I'm finding that other attorneys are also more likely to settle because of the times.
Yeah, mediation can be very effective. And in one of my podcasts that I talked with Jonathan Wynn of our Cordell, Utah office, really talked about the effective ways to use it, even to use a retired judge where the parties agree to actually have a mini trial to get through the process. But I just don't see the advantages of not being represented during that mediation. There's a lot of pressure to resolve, and that mediator doesn't represent either party. They're kind of a third party neutral, so I agree with you in that regard. But in child support, we talk a lot about extracurricular activities, and maybe you can talk to guys watching right now how that is used in the calculation of child support, if at all, and how do courts look at that? Because it's obviously an expense that many kids have, every day.
Well, with our child support, it is strictly set based off of a percentage of the income of the non-custodial parent. And here in Mississippi, we do not even consider the income of the custodial parent, and it's all statutory based on the number of children. In regards to extracurricular activities with that is not included in the figure of child support. There was a 2016 Court of Appeals case that basically defined extracurricular activities as those that are school related. In other words, if the child is playing travel baseball, that's not a school related activity. So that would not be counted in an extracurricular activity unless specifically contracted otherwise. But if he's playing baseball for the junior high or high school team, obviously that is a school-related extracurricular activity, and each party would be obligated for half of that in most cases.
Yeah, and the other issue that comes up, and I see it frequently as we roll out of a school year and then we roll into August with a lot of kids and guys, children are going off to college. The question is, every state has a different emancipation age, whether it's 18, 20, or 21, or 22. But I guess the guys have a lot of questions when their child or children are going away to college and they're spending, let's just say 9 months of the year away, and they're going to another state, another city. They're already paying room and board separately, perhaps. Is there an opportunity for guys to be thinking about modifying their child support because the custodial parent is incurring the kind of expenses they once were because they're now away at school? Is that something that guys should be thinking about?
Well, in Mississippi, we're actually in the minority of states where child support cuts off at 21 instead of 18. And so a lot of times there's already support being owed there. But it's usually unlikely that any college expenses are owed because one of the elements for college support is that the child has to show an aptitude and a desire to attend college. And most children are small when a divorce is taking place, and it's really hard to show that a 7-year-old has a desire to attend college, or any child that matter that's not in high school yet. But pretty much as long as the child is continuing to want to stay in school, they're going to be obligated to pay. Now, if they are not going to college and it's not due to COVID-19 and they're over 18, that may be a basis for modification.
Yeah. And I see around the country different aspects, and each state has a little bit different variances too, where there may be opportunities for guys to think about reducing a support amount only while the child's away. So I encourage guys to think about at least seeking a consultation and having that discussion as we roll into August if we get away from the distance learning and your child is going to go away for school and your emancipation age hasn't hit that number yet. So it's an opportunity as well. So I want to talk a little bit about spousal support, because just like child support, we have guys out there, 8+ million, who probably can't afford their spousal support payment, or they're facing a divorce and now having a decrease in income. It really is a game changer for them in terms of whether or not spousal support is even on the table. So I want to go to Jessica. Jessica in New Hampshire. Again, let's talk about the status of the court system, and then we'll get into the spousal support issue.
Sure. At this time, the courts have extended the stay-at-home order of closing the courts to the public to May 25th. So they're scheduled to open on May 25th. I don't know that that's going to happen, but the courts are open. I'm actually getting orders faster than I ever have. So there's been a little bit of a silver lining, if you will, at least in New Hampshire. So although people can't go into the court, I'm having telephonic hearings. We're doing telephonic Zoom mediations, and people are getting what they need. I do echo that people are finding ways to settle their case. People are deciding that they could live with $1 less here, $1 less there, just to get it done, because they don't want to be stuck in this hamster wheel forever.
Yeah.
So courts are scheduled to open. Jury trials just extended till July 1st. So I don't think it's any secret that family court will extend to July 1st at this point, but I don't know. But they're working, and all courts have an email now. We're still behind the times, and we have to paper file, but they're allowing us to email. So there's ways to get it done, and people don't have to wait. I think the courts are actually hungry to get some work done. So that's a positive note.
And I think we're seeing that in the majority of the states where we're seeing some efficiencies. They're learning the technology, and they're actually getting through cases as fast as they can, realizing that when this is all over and we see some sense of normalcy, there's going to be a crush of filings and a backlog of delays that we've never seen before. At least, my 27 years. When I first started practice, there, cases would take over 2 years. We've gotten to under a year, and so I think we'll see that. But they're doing a great job.
Yeah,
So
yeah.
talk a little bit about New Hampshire, particularly state to state. There's differences in terms of alimony, but I know they have some changes in their alimony laws. Maybe talk a little bit about how that change occurred.
Sure, just briefly. So for a long time, New Hampshire didn't have a calculation to alimony. Spousal support was alive and well. One person had to establish their need. The other person had to establish whether they had the ability to pay. And the judges were all over the place with their orders. So you might had somebody with a need, but the person was able to say they couldn't pay, and then the order came out at 0 or some random number. So basically, it was a sort of wild, wild west calculation. So in 2019, they instituted a calculation, which most states have, that it's going to be 30% of the difference in income between the parties for up to half the length of the marriage. So although that sounds tough to people, they have to remember that the first analysis still is to establish a need, to establish a baseline of expenses and income, and to establish what that other person's ability to pay is. So it's not an automatic payment. And then the courts go to the calculation. So it's still being tested. The judges are using it a little bit different case to case, but that's how I'm prepping my clients, is just let's look at the need, let's look at your ability to pay, and let's look at the length of your marriage, and then we're gonna start somewhere. So it's still being tested, but it's definitely a change from the past.
And it's huge because, every state has something different, and it's always the hardest question sometimes to answer when there is no calculation. So it's a good thing that New Hampshire's going that direction. We can at least give guys some guidance as to what to expect instead of judge variability with the same set of facts. So, one of the things I think is important, we talked about this before, is to maximize, during this pandemic, a lot of people are at home, is to maximize the review of the financial statements that they filed or will be filing. And I'm going to throw up on the screen a graphic, just kind of a generalized example of what you should be expected to be filing and why it's so important. And I thought, Jessica, you can just cover why, what they should be doing now that they have some time to focus on this document.
Yeah, absolutely. So in New Hampshire, we actually have a mandatory rule for discovery and for these financial matters. So the first thing I do with clients is to go over this financial statement. Ours is a little bit different, but it's all the same information. It's extremely important to really gather your taxes, gather your pay stubs, and look at really what your concrete expenses are. Most people don't really know what their breakdown of expenses are. And so now that they have the time, if they're working from home or if they're laid off, I have them do the homework up front, because the better I know their numbers, the better I can help them really find out what that order could be. So really detailing expenses, going back through your bank statements, going back through your taxes, and figuring out your actual income and why your income might have gone up and down throughout the years is extremely important. And people do have the time now, so that's my first homework item to them.
Yeah, I can't understate the importance of this financial document. And now when you have time, get on it, stay on it. Schedule an appointment with your attorney right now to either work on it or review it and make some edits while COVID's happening, because it's just a really good use of your time.
Absolutely.
Carly, I want to go to you. Again, we want to hear what's going on in Oklahoma. And then I want to talk about retroactivity, because we've talked a lot about retroactivity when it relates to child support. I want to talk about spousal. So just give us an update what's going on in the court system in Oklahoma.
Okay, so when the shutdown initially happened, May 15th was this magic day where all the courthouses were going to open back up. That's tomorrow. And what we're seeing is a slow phasing into opening back up. So what was just emergency hearings is now, okay, we're considering setting temporary order hearings. We're considering setting motion hearings, but it's going to be significantly limited on the amount of people that can be in the courtroom. So what was a 20 cases on a docket for a temporary order hearing is now going to be 2, just because of the restrictions and trying to limit it to 10 or less people. So even though we're opening back up, there is still a backlog from the closure, and there's going to be an additional backlog because of how limited the courthouse is.
Yeah, so retroactivity, we've got guys here who a lot of them now realize they can't even make the payment. They can't make the full payment. They don't even know what to pay because their income has been cut. They're still waiting on maybe an unemployment check, and they're trying to prioritize their bills. And so we've talked about stopping the bleeding. And retroactive support. Maybe we talk about what that means and what is that line of demarcation in Oklahoma, meaning that is it filing, is it service, is there another date? When can guys rely on something when they file or to kind of stop that bleeding?
So retroactive modification is whether the court has the authority to change things looking backward once the issue is in front of the judge, or if they can only change things going forward. So in Oklahoma, the court can at any time retroactively modify temporary support alimony. So if your divorce case is pending, at least in the state of Oklahoma, and you can't make those payments at any time before your divorce is finalized, you'll be able to ask the court to either give you credit for that overpayment or to have your ex reimburse you for that overpayment. And it depends on the state that you live in, but sometimes retroactive will only go back to the date that you file that motion, which that's what all of these panelists are talking about. It's so important to get that motion on file because it's going to trigger a series of events going forward. So you want to make sure that you have that.
Yeah, so I mean, I assume doing nothing means you can go file your motion at some point, but you're going to owe that full amount, whether you can afford it or not, if you haven't taken action, right?
Absolutely. And it can also make you more vulnerable to contempt. If you're actively saying, hey, to your ex and to the court, I can't make this payment. I'm trying, but I can't do it. Then it's going to be really hard for them to prove that you willfully violated the order if they file some sort of contempt action against you.
Yeah. James, I want to talk about kind of an use of experts, obviously, and especially when we're looking either an establishment of alimony or the modification of it. Experts are pretty important, but go ahead. Let's again update on what's going on in the court system for you, and then we'll talk about experts.
Absolutely. Scott, South Carolina is almost open for business. We're taking new filings every day. In fact, I filed one 2 days ago, and the court has already scheduled a hearing 2 weeks from now. So I think the judges are ready to get back to work. They're ready to move the docket, the backlog. We're now doing WebEx hearings, Zoom hearings, and affidavit-driven hearings. So relief is readily available in South Carolina, and we are ready to work to help get that done for the client. Going back to your point about using experts in the alimony realm, while we've had some time here, at least, due to no live in-person hearings, these experts have been utilized and can be utilized moving forward to do a complete and total evaluation of the marital estate to get the best numbers possible for when you do actually go in for a trial or a hearing to be prepared. In other words, these judges are going to be looking for help, and help comes through good numbers, good data, good information. And experts do a wonderful job in providing that for the client. So the more time they have to review the financials, the better your chances are at presenting the better data for a judge to make an easier decision and help your case.
Yeah, I mean, I think experts are so important in terms of now really considering it, whether it's an accountant or forensic accountant, kind of going through all of those issues. Sometimes you can't even make your proof to get a modification without them, right?
That's correct. Oftentimes you're going to have to look in a modification action for some kind of substantial change in circumstances. So what we would ask the client to do is bring in their old court order, have a consultation to review that court order, look and see different ways that possibly could have created a substantial change in circumstances. Obviously with the pandemic, that has caused many changes in circumstances. So odds are there could be a potential finding in that court order with an attorney who could help you locate that action. Then you would utilize the expert, if it's a financial issue, to go through and show possibly projections going forward. Obviously, there's loss of business due to this pandemic, and an expert can go and look and possibly give potential future numbers that could potentially ask for a modification. You provide those along with the court order to a judge in a court, they're going to be able to look really hard at giving you a modification and relief immediately.
Absolutely. Well, now it's time, we're going to get to our lightning round with the last 15 minutes. But first, we're going to go to a quick commercial break, and we'll come right back. If you have questions, submit those in the Q&A that you want to ask live. Otherwise, you can submit those in the chat, and I'll go ahead and read those to our group of panel. But we'll be right back to answer your questions live.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell & Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
Well, welcome back. Now it's time to get to the lightning round where we'll answer your questions live. And we've got our first call in that wants to ask live, and we're going to turn this over to Michael in New Jersey, but this is from Jeremy in New Jersey. Jeremy, what's your question?
Hi, thank you for taking my question. I let my ex-spouse have the kids last weekend for Mother's Day, even though the whole weekend was supposed to be my visitation time. Now she says if I want them for Father's Day, she gets to make up that time she missed. I don't think this is fair to our agreement at all, and I was hoping I could get some tips.
Michael, what do you say?
Jeremy, thank you for your question. So if I understand your question correctly, you allowed the children to spend some time with mother on Mother's Day, and now she's claiming that that she should have them for Father's Day. I mean, I think the first thing you're going to want to do is you're going to look at your custody order or your agreement that's in place right now to see what the terms are. So as a general proposition in New Jersey, if it's subject to a holiday schedule, then you would have them on Father's Day and she would have them on Mother's Day, and that's typically how that would occur. If she does withhold them from you on Father's Day and you're entitled to have them, then she's probably in contempt of the current order, provided that language is in there. So at that point, then you would have an opportunity to file a petition or file a motion for enforcement and contempt. And you could even seek counsel fees if necessary. I mean, but I think right now, it would be the time to, you want to make clear in your communications with her that, that's your time, your dedicated time with her, with your children. You fully expect to have that time during Father's Day pursuant to your order. But I think in that communication with her, make sure that your tone is cordial, make sure that you're respectful and polite. You want to be, you want to make sure that you're addressing your immediate needs, but you also want to play the long game here too. And you don't want to give her an opportunity to potentially go into court and argue that make an argument that you're badgering or harassing her potentially. But I think the bottom line is go take a look at your order. If your order says that you get them on Father's Day, then you should absolutely have them on Father's Day. If you can come talk, if you want to talk to an attorney, get out in front of it, you can send a letter to her counsel and indicate, your intention to have them on Father's Day. But ultimately, if she violates the order, you're going to have recourse through the courts, and it's not going to be a good look for her.
Yeah. All right, Ian, you have a question. We're going to turn this over to James in South Carolina. Ian.
Hi, thank you for taking my question. My main issue is that my ex has had at one point contracted the coronavirus. She did not tell me when she did. She would not give me details on it. I tried to figure out when I could see my son again, but it was an issue because I have other children that I didn't want to have exposed to it. So I unfortunately a few times had to deny a visit with my son because I didn't know the facts. Eventually I wound up, working backwards from a little bit of information and pieced together when I could see him again. But she's threatened me because of this. And since it's such an unprecedented situation, I haven't been sure how to act. Thus far, he's been fine and everything's okay now, but Yeah.
Well, thanks,
Sure.
Ian. James, I think what he wants to know is really what he should be doing. I think one is communication, documenting is important too, but I'll turn it over to you, James.
Absolutely, and I appreciate the question. What we would ask you probably to do right off the bat is to let us review your court order, see exactly what type of custodial relationship you have with your ex-wife. At that point, we would then look into see exactly which provisions allow for medical decisions and things of that nature. Obviously, you're not going to expose your child to a coronavirus and put your child in danger if that is indeed what has happened with your ex-wife. I think a court would be sympathetic to that. However, at the same time, without looking at your order in more detail, you certainly don't want to move forward and constantly do a blanket withholding of visitation for an extended period of time because you could find yourself in a contempt action at that point. But I think you need to get a little bit more information. And I think what Scott said about documentation, asking for a medical documentation that she's all clear, maybe a negative testing, something more than just let me see him after you tell him after she's told you she's had coronavirus. The more information, the better. But I would certainly contact an attorney to review that order.
Yeah, I think, Ian, it is. It's just send that letter, be direct, just like you are now. I don't know what to do. Here's the, what should I be doing here? I understand this, ask for information. And I think if anything, at the end of the day, the court system would look at that favorably for you. So let's go to Bob. Carly, I'm going to turn this over to you. Bob from Virginia wants to know what the legal definition of a change in circumstances is typically, and for in Oklahoma where they can, that's defined, and typically I think it's by statute, but what is a change in circumstances, Carly?
So it's vague for a reason, and I think it's vague so that the court has a lot of wiggle room. So a change in circumstance can mean really a variety of things. I always tell my clients that the more bricks we can lay in the wall, the stronger it is. So a bunch of little changes can accumulate together to be a big enough overall change in circumstances. And when we're talking about modifying child support, in Oklahoma, DHS likes to make things easy for themselves, so they just do a blanket, if it's changed up or down 20%. And for my clients, I always like to start at that 20%. So as your income changed 20% or more during this time, and maybe that's going to be the basis to modify either support alimony or child support.
Yeah, and I think it really is. It's by case law, by statute. It is, as you suggest, Carly, very vague and intentionally so, so that the courts do have the discretion. But it's really looking at what was the facts at the time of the last judgment, and has something changed, and something that's in there, not just a change in circumstances, but that word that's so important, continuing. And that's really important to look at, a substantial and continuing change in circumstance. That is something as well. So let's go to VJ in Virginia, and we're going to turn this over to Oliver. VJ, Oliver says, is there case law I can use? And VJ pays $1,200 per month in spousal support and what appears to be 7 years left. Seems to be a fixed amount. VJ retires here in another month. Ex-wife is starting to get 25% of VJ's retirement, which is about $1,400 or $1,500 a month. VJ is going to be employed at least 2 months before starting the next career as a teacher. And currently the order imputes about $40,000 of overtime into the salary. She was a stay-at-home mom and unemployed. They did impute some salary to her, and he pays child support as well. So I can imagine VJ is just looking to determine, what's out there to guide VJ on potential modifications, maybe of child support, and how to deal with even the maintenance. But it may be that it's a non-modifiable amount. But I'll leave that to you, Oliver.
Thanks for the question, VJ. When it comes to law here in Ohio, again, we're talking about that substantial change of circumstance. One thing that we need to consider here in Ohio is whether or not that change of circumstance is foreseeable. So in order to meet that criteria, that threshold to allow us to go in for a modification, we need a substantial change of circumstance that wasn't foreseeable at the time that the original order was entered. So, what we would do here is we would look at your initial order, your initial decree, see what the modification language is, whether or not the court retained jurisdiction to modify the amount, the duration, both or neither. We would look at everything that you're paying, everything that she's receiving, and we'd go back to that discovery stuff that was talked about a little bit earlier, and making sure that we have a full disclosure of what your financial situation looks like, make sure that we understand what your ex's financial situation looks like, and then we would just look at where you were when the initial order was entered into and where you are now. What's changed, what was foreseeable, and I think a breakdown of all of that information will kind of guide whether or not we're able to do anything on that.
Yeah. All right, Jared, coming to you. A question comes in from Walton, Illinois, asking, can my ex-wife seek to adjust child support if she lost her job due to COVID and Walt is still employed? So Jared, that's a question about modification of support where she may seek to increase because she lost her job potentially.
If she is the custodial parent, her change in circumstances here is probably not a reason to get an increase from him, because in Mississippi, again, we're in the minority of states where child support is solely based off of the income of the payor. In other words, the income of the non-custodial parent. And so if he were to get a big increase, which probably hasn't happened during COVID-19, then that would be a basis. But we really don't consider the income of the custodial parent in this state.
And I think, as you suggest, that's right on in terms of those states that only recognize the payor income, and those states that look at it maybe perhaps a joint income. That's where I think what's important to understand is that word I mentioned earlier when we define substantial change, it's got to be continuing in most states, meaning this could be a temporary layoff, it could be a temporary decrease. So I think this is an opportunity where, well, in Illinois, you want to go consult with a lawyer. Obviously, we have multiple offices throughout the state, and just find out exactly could happen if she seeks to increase the child support. So let's go to Jessica on the next one. Jessica, we have Michael has a question. Wife was diagnosed as bipolar 3 years ago. She's been in denial. Now we've been living separate lives in the same house. After COVID, she decided to take the child to her grandmother an hour and a half away. I'm finding it hard to get a compromise from her regarding spending more time with my child, but just a few hours a week right now. Do I mention bipolar when I file the petition for divorce or visitation? And that really, Jessica, is a question, is it going to matter in a custody battle if mom's got a history of mental disease or some issues that may affect it?
Right. So the courts do want to know if parents have untreated mental disease. And that's really the key. So just if it's alcoholism or if it's a drug addiction or if it's mental disease, the courts care because that's not in the best interest of the children. So they're not judging her for being bipolar, but they want to know what steps is she taking to be safe. So her decisions right now, if she's untreated or in a manic episode and she's not taking care of herself and she decided to take the child away from you for that reason, and there's no valid reason, if you're no more exposed than she is to COVID, and yet she's taken the child, the judge will look badly upon that.
Yeah.
So they don't want mudslinging. They don't want to shame people for their mental health problems. But if mom is diagnosed and mom is failing to take care of herself in a manner that makes her a good parent, the courts certainly do want to know that. Does it go in the initial petition? I think that's a decision that the attorney and the client can make at the time, deciding what the court needs to know. Do we need to file an emergency petition? Is this child not being returned to dad? And if that's the case, we may have to put that right out there to the court, saying we need to get into court today because we need this kid back for safety reasons. If the child is returned and everyone's safe and we just need to proceed with the divorce, maybe we save that for another day. So I think it depends a little bit on the exigent circumstances at the time of filing.
Yeah. James, I want to toss this one to you from Virginia. X is a medical doctor and is putting the child in the care of her parents, who are obviously the grandparents, who are elderly with pre-existing medical conditions. This is during her time, but I'm available to care for them due to my stay-at-home work schedule, and she's not allowing it. He's fully capable of caring for them during that time. Should he be concerned about this or put my ex on notice? I mean, one other question, she also comes home from the medical clinic every day and takes care of the kids after work, again during her time, and since I only have the kids every other weekend. That's obviously similar to the questions we've talked about in some of the news articles about doctors and perhaps the increased exposure. But I guess the question really from Virginia is, should they put him on notice that he's available, what I would refer to as that right of first refusal? And should he be documenting, hey, you're putting the children at risk with someone who's elderly, pre-existing conditions, and you coming home every day from the medical clinic? I'll turn that to you, James.
Sure, absolutely. I think that he does need to document this as the request that he has for the children, letting her know, hey, I'm available. My schedule's open to have the children. And this could be a bigger issue that's come to light. If he's got a stay-at-home job, this could be the perfect opportunity to file potentially for a modification, not only on a temporary, but for a permanent, just to show that he's a lot more available if that circumstance has changed from the time he has finished the last divorce decree. So we'd look at the divorce decree, look at the options there. I would document as courteously as possible to her, saying that I'm available. And then just let her know your concerns right off the bat, that I'm concerned about your parents and the children and your exposure. What kind of precautions are you taking to keep these children and your parents safe during this time, and go from that way.
Yeah. Carly, real quickly, we're going to go to you. This question is, as a part of the settlement agreement, I agreed to pay alimony for 2.5 years. My ex is still under or unemployed. Can she file a motion for an extension for something that appears to be a defined term? Maybe it's non-modifiable. Maybe also can she seek to increase that amount? We're going to make that assumption that it's non-modifiable. So extend or increase.
So because you guys agreed to it, and most jurisdictions don't allow you to modify it. And in the question, I'm assuming that she was underemployed at the time that you guys entered into that agreement. You guys entered into that agreement at a time considering all of your finances at that time. She can't voluntarily be underemployed so that she can get future support. So I think it really depends on whether your jurisdiction allows it. But in Oklahoma, really, you can modify it downward, but it's a very rare circumstance where a party can go back to the court and say, I need more money. So that would be something that's really rare, and it really would depend on your jurisdiction.
Yep. And Michael, I'm going to turn this to you. We have about 45 seconds to answer this one. Joseph bought a house before the current marriage. Prior to now having issues, he did refinance it and had his spouse co-sign on a refinance. The question becomes, Joseph wants to know whether or not that's still, is it separate property? Is it marital property? And I know state by state would vary, but maybe you can talk a little bit about New Jersey and maybe give Joseph some ideas on what he should be looking for to determine its character.
Sure. So I think as a general proposition, I mean, the argument in New Jersey would be that it's separate property, that it was purchased prior to the marriage, but the issue you're going to run into is with the refinance. So there's the possibility that, that if there's been an increase in value, post date of marriage, that perhaps that increase in value may be marital and may be subject to property division or equitable distribution. But I think as a general proposition, the argument, at least from our end, would be that that was a property that you owned prior to the marriage, and it's your marriage. The other thing I would want to look at is I'd want to look at your deed and the title. So while you talk about the refinance and the fact that the mortgage obligation is now something that both of you share, is have you transferred any title interest to her, or is the deed solely in your name at this point? Because I think that's also going to be an important fact. It's something definitely worth considering, but I think as a general proposition, again, the argument would be that it's premarital property, but the increase in value may be subject to equitable distribution.
Yeah, there are particular nuances with the character and designating it as marital or separate that you're going to want to check out, Joseph, with an attorney. And obviously you can contact us at CordellCordell.com or 866-DADS-LAW, and we certainly, our attorneys can answer that question for you. So that wraps it up for today's virtual town hall. I encourage you to tune in next week, where again, you can ask your questions and ask them live and get answers. You can also tune into the daily podcast, where we're going to spend 15 or so minutes really on spot issues that you have in your case with this pandemic and all issues of family law. So that's it for this time. And until next time, have a great week.